Well, good afternoon, Michiganders. It is Tuesday, January 25th, 2022. And of course, this is Tuesday with Tom, Michigan's only weekly internet show where we do answer your questions about estate planning and estate settlement in Michigan. I'm your host, Tom Doyle, estate planning attorney, lifelong Michigan resident, and an ambassador for all things good in this great state of Michigan. Welcome to today's program. Well, last week's episode, 12 estate planning questions that might make you squirm if you're thinking about putting your estate plan together. Some questions that are important for you to consider in advance of meeting with the attorney who's going to be working on your estate plan. Today's show, what the heck is an UTMA? And should you use one as part of your estate plan? But please remember, what I'm about to discuss during the program is, as always, for educational purposes only. It is not intended to be legal advice. You need to work with your attorney to determine what is appropriate for you and your estate plan. What the heck is an UTMA? And as important as that, should you use one as part of your estate plan? Perhaps, and this only applies to folks who are looking at leaving some sort of an inheritance for a minor, and they're looking at their estate plan and they're saying, I would like to leave something, maybe a bank account, maybe some investment properties, whatever it happens to be, to a minor, but I don't want the minor to be able to access the inheritance until they are an adult. So what are the options? Well, one option that a number of clients are going to use is just leave it to your brother Bob. What do I mean by that? Well, you simply make Bob the beneficiary on the bank account or on the investment account, whatever it happens to be, and you have an agreement with Bob where Bob is going to hold on to it and eventually give it to your child, maybe when they turn 18 or turn 21, whatever it happens to be that you and Bob agree to. Well, a lot of people are going to enter into these sort of informal agreements, but before you do that, there are some important questions that you have to consider. One, what if Bob just spends it on himself? Maybe Bob decides he wants to go to the Bahamas and he spends the money, and so there's no money left over to give to your child. Or what if Bob dies? You need to think about that, because if Bob dies, it's part of his estate plan, and now it's going to go where his estate plan goes, which probably is not to the minor that you wanted the estate to go to. Or what happens, maybe Bob's married and he gets divorced. Now it could be tied up in the divorce settlement, or just in general, that asset that's now owned by Bob is going to be subject to claims of Bob's creditors. And finally, if Bob does give the asset to the minor, maybe when they turn 18 or 21, think about what Bob's doing. He's making a gift. It's not an inheritance to the minor. Bob is making a gift to the minor, and now gift taxes need to be considered. So you can have an informal agreement, but probably not something that you're going to really want to count on. So what's another option? Well, another option is to have a conservator appointed. Somebody can go to the probate court now, because conservators only get appointed through the probate court, petition the probate court. They're obviously going to hire an attorney, such as Amanda or myself, to probate that, set up that conservator. So it's going to be expensive, and it's going to require court hearings, and it's going to require notifications go to particular individuals who might have something to say about whether or not that conservator should be set up, or who the conservator should be. And perhaps as important as all of those things, it ends when the protected child turns 18. So a conservatorship is only going to only going to manage that estate for that minor until the minor turns 18. So another option that a lot of clients are going to think about, having a living trust. Having a living trust, I've had many episodes in this program before about living trust. Certainly, it'll avoid probate, so you don't have the whole conservatorship cost issue that you've got in going a conservator route. And you have unlimited options at when that trust is ultimately going to be distributed. Maybe it'll be 18, maybe it'll be 21, maybe 25, maybe half at 25, half at 30. You've got all kinds of options available to you for when that trust will ultimately distribute out to the beneficiary. Obviously, it's going to cost money to set it up, and depending upon the attorney that you're working with, it might be an expensive venture for you, but it's certainly an option. And it is certainly something that many of you are considering when you've got other issues that you're looking at relative to your estate plan. Maybe you're looking at trying to avoid probate and you have other assets that have to avoid probate, even though they're not going to a minor. But it is an option, even if you're just dealing with a minor. But there's another thing for you to consider that might make sense to you, and that is an UTMA. UTMA. What is an UTMA? An UTMA is a Uniform Transfers to Minors account. That's what it is. It can be fairly inexpensive to set it up. The downside, and we're going to talk about what's required to have an UTMA, but one of the downsides of the UTMA, well, one of the pluses of the UTMA, it's going to avoid probate, so the asset is going to go to the minor without having to go through probate. One of the downsides, though, is it's going to have to end at age 18, just like that conservatorship, or with appropriate planning, can at least extend till 21. So if you're looking and saying, hey, I don't want the minor to receive it when they turn 18, but I want it to go till 21, that would be an option for you under an UTMA. So what can you do? Basically, Michigan has a statute, the Michigan Uniform Transfers to Minors Act, and that's what sets out the parameters that have to be met in order to have an UTMA. And essentially, it's fairly simple. That is the minor, that's the person who's going to receive the inheritance, or the custodian, that's going to be the person who's going to hold on to whatever the asset happens to be, have to be a resident of the state of Michigan, or the property that's going to be managed for the minor has to be located in the state of Michigan. So not a lot by way of requirements, but there obviously has to be a connection with the state of Michigan. So you've got some options. One option is you can make a revocable nomination. That means you can change your mind about it. You can put an UTMA together that you can change later on if that's what you choose to do. And it can be as simple as in whatever document you're dealing with, you simply indicate that so-and-so as custodian for the name of the minor under the Michigan Uniform Transfers to Minors Act. That's essentially what's required under the statute to create that UTMA. You can also have substitute custodians. That would be who the property is going to go to and manage for the minor if the first custodian dies or is unable for some reason to continue serving as a custodian. So you've got some options where you can have an alternate person name. You can also set up that UTMA in a will. You can set it up in a trust. You can set it up in a deed. Depending upon what you're looking at doing, you can do it in some sort of designation outside of all those things. It can be done, for example, at a bank. Most of the banks that you're going to deal with, credit unions that you're going to deal with, likely can set up an UTMA account for you. Financial services companies, the Merrill Lynches of the world, Edward Jones, etc. Check with your financial advisor. They likely have the ability to have UTMAs created for you relative to your investments that they happen to be managed for you. So you're going to have a lot of options out there for creating that UTMA for the minor. As I said, it can be revocable where you can change your mind, or it can be irrevocable, meaning once you set it up, it's done. All right, it can't be undone. It's there until ultimately the time frame that you've established, the asset can ultimately pass on to the minor. And again, it can be age 18, but with appropriate planning, you can actually choose to have it managed for the minor until they're 21. In fact, a personal representative under a will or a trustee or even a conservator can set up an UTMA if it's appropriate. Okay, and that is where the personal representative or the trustee or the conservator determines that it's in the best interest of the minor child, and there's nothing in the document itself that says that they can't do it. So even a personal representative under will or a trustee of a trust or a conservator can do it. However, if the transfer exceeds more than $10,000 in value, then they're going to require authorization by the probate court. So there are some options available to you, to a trustee, to a personal representative, etc., as creating an account. Think of it as basically creating an account. As simple as what most people are going to do. They're going to go to the bank, they're going to go to the credit union, they're going to give them a sum of money that's going to be put into an UTMA account and ultimately will stay in that UTMA account and then be distributed out to that minor at age 18 or again age 21. The money that's in the account can actually be used to support the minor until they turn 18 or 21. A custodian can use the account without court order in order to provide for the use of the minor as the custodian deems appropriate. Obviously, though, if you're going to be dealing with a bank or credit union or a financial services company, they're not going to be interested in making those decisions. They're simply going to hold on to the account until they get to be age 18 or 21, which quite frankly is what most people do. At age 18 or 21, it will be a lump sum distribution. Account is closed, money is handed out, okay? But again, maybe you're going to simply be dealing with a bank account. Maybe you're going to be dealing with a brokerage account. It can actually deal with real estate that way. So there are a number of assets that can be utilized in establishing that UTMA. So what the heck is an UTMA? An UTMA is a uniform transfers to minor account that might be appropriate for you if you're looking at, as part of your estate plan, making a distribution to a minor, and you don't want the minor to receive that until maybe they're 18 or 21, and you don't want to involve the probate court or perhaps involve the expense of going to a trust, or you don't trust or you don't want to simply have that informal arrangement with your brother Bob. Of course, a reminder too today that Amanda and I obviously would be the honor to assist you in putting together your estate plan or amending a plan, helping you decide about having an UTMA as part of that plan. We certainly aren't a financial services, but we can certainly discuss how you can incorporate that UTMA as part of your plan. Again, because of COVID, we're simply doing everything through virtual. We have our virtual office at doylawpc.com for prospective clients. You'll find our planning from home service. You can download our free estate planning guidebook, set up a consultation, either Zoom or telephone. Zoom is not one of the consultation options that you have available for you. Current clients, additionally, through the virtual office can ask about getting their plans updated, again, schedule consultations with us. And of course, if you go to Doyle Law PC, you're going to find the legal store where there are a number of legal documents such as certificates of trust, different legal documents that might be appropriate for you as part of your estate plan that you are able to order online as well. Well, I think that's going to be it for today's show. As always, though, if you have a question or a comment about the show, maybe a topic that you'd like to have me discuss, please send me an email, tom@tuesdaywithtom.com. That's the easiest way to get it to me. Or you can always mail me a postcard, Tom Doyle, P.O. Box 16066, Lansing, Michigan 48901. And as always, we encourage you, please follow us on Facebook and Twitter at Tuesday with Tom. Follow the office as well at both Facebook and Twitter at Doyle Law PC. Remember, too, that the program is available probably wherever you listen to your podcast, be it Apple Podcasts, Spotify, Google, iHeartRadio, Spreaker, a number of alternatives that you will find where the podcast is going to be available. Or you can normally ask your smart speaker to play Tuesday with Tom as well. Thank you again for spending some of your time with us today. And as always, I hope that you have an awesome day and an awesome week in Michigan. Stay safe. Tuesday with Tom has been brought to you by the estate planning attorneys at Doyle Law PC. To learn how we can help you with your estate plan or with settling a loved one's estate, please call us today at 517-323-7366. That's 517-323-7366.